Hi friends, hope you're well. I'm back for part 4 of a series on practical tips on contract review. Do watch the previous videos. They have basic guidance on how we start reading and understanding a contractual document in our initial days of reviewing contracts. Today, we'll understand a bit more about why we have written contracts. Let's get the simple reason out of the way. Some kinds of contracts require a written form and even registration. As an example, property sale purchase documents in most countries. There is no real choice there. Other than those, why do we have contracts in a written form? We did learn in law school that oral or verbal contracts are acceptable too. But then, here are the practical challenges with following that. 1. It would become a he says, she says thing. How does one prove which party is accurate when both claim different versions? This might not even be deliberate. It could just be a gap in understanding or memory. Or, considering that lots of communications happen by emails and messages, the parties and even the judge would have to figure out from that kind of chaotic communication what was finally agreed. So, one of the main reasons is around evidence and enforcement. It does not mean that evidence will include just one contract and no other documents, but it might reduce the chaos to some extent. There is a clause in most contracts which is called entire agreement clause, which is related to this as well, and we will talk about that at the end of this video. This clause helps separate the wheat from the chaff. This was on the litigation or contentious side. My experience is more on the corporate or business side, where there are additional reasons. For execution as well as business continuity, it's important to have the details in an objective form. So, if anyone related to the project but not directly involved wants to refer to it for project execution, they can do so. For example, the finance department wants to see whether the invoice that they receive for payment is to be paid immediately or them paying after 45 days is still okay. They might want to check this because if they're late in payment, there could be late payment charges. Or a senior management team member who's in charge of the company website and is waiting for a technology product installation managed by the IT department wants to see what is the timetable committed by the service provider and whether they are on track. Also, when the person who knew about the transaction and negotiated it is no longer around for any reason, it's captured in a tangible form and can be easily referred back to. Yet another but very important reason is checks and balances to prevent unethical behavior. Well established organizations, especially the ones which are listed on stock exchanges, are also subject to far more stringent audit requirements. An important part of audits is to check if adequate contracts and documentation are in place and also if what's happening on the ground is the same as what's mentioned in the contract, including preventing unauthorized payments. It also helps in some level of certainty and contingency planning by being aware of the risks. Another reason is that it has a certain level of deterrent value by reminding the parties that there could be repercussions if they don't fulfill the obligations, going back to the topics that we covered in the previous videos. This might not just be at the dispute stage, it might even be at the day to day operations stage, where, as an example, one party wants to refer back to and implement committed timelines and penalties. So, now coming back to the entire agreement clause, it's a standard contractual clause or boilerplate clause as they're called saying that this contract is the only document for this arrangement and any verbal or written communications or discussions before this are replaced. The idea is the same: not go around on a wild goose chase trying to retrieve hundreds of different emails trying to prove a case. Rather, have one document, include everything relevant there, and treat that as comprehensive and final. Of course, in a dispute, emails still might have persuasive value to show the intention, especially in cases of differences in interpretation depending on the country and the court. Hope that was clear. Thank you so much for your time. I'll be back again.